Great. Well, welcome everybody to another compliance live briefing. My name is Brian Feeley. I'm Senior Vice President of Marketing for Corporate Synergies. Really glad to see, wow, a growing list of people that are joining the call all of a sudden. So that's awesome. With me today, many of you are now familiar because we've been doing this for the last couple of months with the same crew here. Dan Kuperstein, our Senior Vice President of Compliance, our ERISA attorney, the expert and guru as it relates to compliance. He is here to answer all of your questions and make sense of this craziness that is going on. And of course, Ray Kim, who you now know is our Regional Vice President of Account Management in the Philadelphia region, very tied to everything that's happening with our clients and trying to navigate the complexities that Dan is speaking to today as it relates to compliance. But we'll hear from Ray on some of the things that are probably in the window view for our clients as we head into the new year. So Dan, you know, the last time we spoke, it wasn't that long ago, and we were gearing up for, hey, OSHA is going to be coming out with the mandate, and they're going to have all the particulars for us to just digest and figure out what we're going to do. Well, they did. And it's been digested, and I think we have some legal considerations here. And so why don't you go ahead, before we get to Ray, why don't you just really make us understand what is happening here right now? A lot of news, even as late as last night. Give us the lay of the land as it relates to the mandate and now the stay that has been put in place against that.
Sure, yeah. So I'll try to go through this quickly and give kind of the bird's eye view or big picture view because there's a lot of details here. But basically, as I'm sure most of you know, on November 4th, OSHA released its emergency temporary standard regulation, which requires large employers with 100 or more employees to make sure that their employees are either vaccinated or that they get tested for COVID-19 on a weekly basis. And that has to be done by that had to be done by January 4th of 2022. And that, you know, generally the ETS also required such employers to provide employees with paid leave to get vaccinated, to implement either a vaccination or testing policy, as well as a number of other compliance requirements by December 6th of this year. And then on November 6th, just a couple days later, the Fifth Circuit Court of Appeals issued a temporary stay of the ETS, effectively blocking its enforcement on a temporary basis until a final decision could be made. And then subsequently on November 12th, not too long ago, Friday, the Fifth Circuit Court issued an order and decision upholding the stay of that temporary stay of the ETS, which basically just prohibits OSHA from enforcing and implementing the ETS pending judicial review of a motion for permanent injunction, which, you know, in plain English, basically there has to be another, court that has to review that, right? And pending such review, that November 12th decision, that ruling, effectively nullifies the ETS because OSHA is now barred from both enforcing and implementing the ETS. As a result of that, right, the December 6th and January 4th deadlines are technically no longer in effect pending such review. And since we'll have to wait for this next circuit court to make its decision on the Fifth Circuit Court's decision, and then potentially the U.S. Supreme Court could weigh in as well, right, the Fifth Circuit's decision was not by any means a final say, but it's unlikely that those December 6th and January 4th deadlines are still going to stay. So it's most likely you're not going to have to comply by those dates. And then most recently, last night, there was when deciding on which court would ultimately review the Fifth Circuit's decision, they held a ping pong ball lottery. It was used to determine which circuit court would be hearing that that Fifth Circuit decision, and the ping pong ball lottery won in favor of the Sixth Circuit Court of Appeals, which, based in Ohio, the Sixth Circuit Court of Appeals tends to lean conservative, and so obviously a number of people, a number of employer groups and conservative groups who were opposing the ETS, that was a big victory for them because they, in their view, they see it as likely that the Sixth Circuit will agree with the Fifth Circuit's decision to block the ETS. So That's the big picture. I'm sorry if I.
Well, that's the legal description of that. But basically, the mandate is stopped, and it's like that big ship in the Suez Canal. It's blocked, right? Nothing's coming in or out. It's blocked. But there's a but, and it sounds like the court that's going to be hearing this for final decision, right? So it's been blocked. It's not moving forward, and now it's kicked to the Circuit Appeals to decide on it, and they are very conservative, you said, right? And so it's most likely leaning towards, if they were to decide, if you were to bet money, where are they going to fall? Is this going to remain, it's done, or are they going to allow it? What would you, if you had to bet? We're not betting. By the way, we do not condone betting, nor is this a betting organization. But if you had to bet, Dan, what would you say?
I guess your question is, what is your view on the long-term viability?
You can legalese my question if you want, but yeah, what do you, come on, tell us what you think.
Obviously not taking any political views, which we don't do, right? So, what we always recommend at corporate synergies, of course, and, is, on the compliance team, right, is that all of our clients take the prudent course of action, right? Prepare for any eventuality, follow best practices for compliance. Sometimes what we call it the belts and suspenders approach, right? Because your safe approach to compliance, which is to be prepared, right, for any eventuality, because like we said before, right, the Fifth Circuit is not, it's not going to be the ultimate say here, right? There's still 2 more courts to go,
right?
But right, that being said, I think you have to look at it from the standpoint, and I think probably where I would put my money is that it may not make it because it still has a long way to travel.
It's wounded.
It's very wounded, yes. And there's a long way for this ETS to go, really, before you can say that, before you can say that it's going to be viable. And I think, one way to look at this is that, right, there's 2 big roadblocks here, right? One, you have this 22-page decision by the Fifth Circuit Court of Appeals that, makes a lot of arguments that poking holes into this ETS. And secondly, right, is the fact that its only chance of survival now rests in, or hinges on 2 conservative-leaning courts, right? The Sixth Circuit Court of Appeals, which is in Ohio, and it's the jurisdiction of Kentucky, Michigan, Tennessee, Ohio. So you've got that conservative-leaning court that's going to weigh in, and then potentially the U.S. Supreme Court, which is also leaning conservative. And so let's also just focus for a minute also on that Fifth Circuit decision, because it really shed some light on some significant inconsistencies within the ETS. And while these may not necessarily be fatal flaws like the court said, they certainly are big problems for the ETS and its viability. And I think first of all, and of course you can read more about this in our e-alert or read the decision itself, obviously, but if you want to get more of the details, you can do that. But one of the big problems here is that the regulation, in order to kind of stay alive, has to show that it's necessity, right? It has to show that the rule is necessary to protect employees from grave danger due to exposure to substances or agents determined to be toxic or physically harmful, as contemplated in the OSHA Act of 1970. And on that point, the court says the ETS is both over-inclusive and under-inclusive. And in plain English, right, it's saying, look, if this pandemic is such a grave threat to the workplace, why is it that employers with less than 100 employees do not have to comply? I mean, is the danger less grave for those smaller employers? And they're saying certainly that doesn't make sense. And in that sense, they view it as under-inclusive. That is, it doesn't seem like, that part really makes sense. And then also, not every employer is the same. So how can you impose something like this that is so administratively burdensome on every employer with 100 or more employees when, workers and workplaces are so different all across the country. And so here the court's saying that the ETS is like a sledgehammer. It's overly regulating all of these different employers when these may be very different workplaces. In that sense, it's over-inclusive. And I'm probably oversimplifying here, but that's essentially what the decision is saying. And those are, if you just look at that sort of, just look at that. And I mean, those are still very strong and compelling points, and points are likely to be taken very seriously by the Sixth Circuit and potentially by the U.S. Supreme Court as well. So I think when you look at all of that, I think my betting money would probably be that it's not going to survive. So,
but as you said, and as we've seen, and we've talked about this the last 2 briefings, we've given examples of things that were dead. They were going away without a doubt, and yet they didn't. And, people were making decisions because there was no way that we were going to go through with information reporting. We talked about that as an example. And of course, we ended up doing that. And people who were late to that game, maybe got caught behind a little bit. And we, as you said, very, very nicely, that, hey, we always talk to our clients about being prepared nonetheless. And I know, Ray, you have done a lot of work in preparation for this going through, because you have to plan for that. And I know that there's a lot of things that you were looking at as it relates to this, if it is the case that this does go through in some version eventually. But I want to hear about that, because I think everybody should know all the work that was done in advance, and they may still have to understand and be prepared for some of those things, whether there's a law for it or not. Some employers are looking to go through with a mandate. They're looking at surcharges. They're looking at testing. So we're looking at this from the law point of view, the federal mandate and the pushback and what have you. But at the same time, employers are making decisions to say, this is what I want to implement. So I would still be curious. Here we are, maybe 3-4 weeks later. I'd love to hear what clients are still considering, and as they consider doing their own mandates, their testing, surcharges, and things of that nature. Dan, you weigh in and say, yeah, good, no good, be careful, whatever it would be. But maybe, Ray, we start with, you had already done some research should this go through. Talk to us about the testing and some of the things that you were dealing with in vetting some of this stuff out. You don't have to spend a lot of time. Maybe we have to come back if this thing comes through and really get into the details. But share some of the work that you've been doing over the last several weeks, so that we have about 200 people on the line. They can hear about some of the things that you were considering.
Yeah, sure, Brian. I think the consensus may be that this is a little bit of a relief for employers, regardless of the way you look at it. I mean, it was coming right up against, the vast majority of our clients are a 1/1 renewal. And from a planning standpoint, that kind of threw another element that may have made the holidays a little bit more stressful for our employers. And so I think a lot of people will view this as somewhat of a relief, at least a delay. And so, when we're talking about vendors, it really is something that I think will maybe be put on the back burner a little bit until there is some clarity coming out of the 6th district. But that being said, we talk about it a lot. Dan alluded to it, belts and suspenders, and just having the wherewithal to evaluate your population and evaluate how you're going to administer it is still steps that I think every employer should minimally take. And we talked about how we were going to go about that process as a consultant or as an employer. And so we should talk about top 3 questions to ask as an employer relative to evaluation. One is whether or not you are going to enforce mandatory vaccinations or not, or do some type of hybrid where you're going to allow for testing, much like the ETS originally proposed. And if so, if you are going to be doing some testing, which employees are they? A lot of companies have workers that can work from home, and so maybe those folks are segmented off, and so you've reduced some of your administrative burden because maybe half of your population is a work from home, or even in the entire population is. So what does that look like in your organization? And then how are you going to administer the program ultimately is the key question, right? Are we going to do that in-house or through a third-party vendor? And so as you're contemplating building out a program, I think the starting point is really the data. What size of scale are we dealing with here? And I think the best way to do this is to survey your employees. We talked about this on the last webinar. How do you know what the administrative burden or the cost, quite frankly, is going to be without first evaluating what percentage of your population is vaccinated today versus not, and who those people are that you are going to have testing? And so that's where it starts, Brian. And then we can certainly get into some of the particulars relative to third party versus in-house.
Have more of your clients made decisions at this point, regardless of the mandate? Are you finding that?
No, yeah, we're still
holding?
in very much question mode right now. I mean, certainly almost every employer that I haven't run across a client of ours that hasn't put some type of policy in place, whether that be social distancing, 6 feet apart, entryways into the building, being quarantined if you're reporting that you're positive, getting tests done. They're all varieties of methodologies and protocols that they have implemented. But in terms of adhering to the specific letter of the law relative to the OSHA ETS before the ruling, no, there hasn't been a wholesale reaction to that in terms of we weren't going to do something. We were going to do our normal protocols and we were going to actually comply, and we were going down this road to comply. There was no employer like that made those types of decisions. They were waiting. We had larger employers, as we discussed in the previous webinar, that because of who they are, because of the clientele that they have, that they serve, had already gone down this road. So they implemented, as a private employer, their own types of policies. Maybe it would have been mandatory vaccination or what have you. So it ran the scale. Certainly when the OSHA ETS came out, we thought this was going to be one of those things where we had to come up with solutions, because the vast majority of our clients are 100 plus. And so everyone was going to have to do something, whether it be in-house or third party.
And it was interesting because we had talked about it in advance of this, even before the stay and the recent information last night. But the whole idea of testing wasn't so easy, was it? I mean, it had to be a proctored test, and that also threw a wrench into things, right?
Yeah, I think that was it flew under the radar there too, because if you talk to any third-party vendor that is supplying testing, the vast majority of them are not supplying a proctored test. Quite frankly, they're not even doing much on site anymore. And most of the vendors that I've spoken with is because there is a steering to take-home tests, rapid tests, because number one, they're quicker, easier to administer, but it's also very difficult right now to have phlebotomists and nurses supply the actual test to their population on site. Plus you have multiple shift workers from home, things like that made it very challenging for these vendors to administer and supply the human power to do the actual on-site activity. So the vendors themselves were going to rapid tests at home and taking them at home, but there are only one or two vendors that we've spoken with a ton, Brian, that actually had the ability to do an observed or proctored test, which was, again, part of the original OSHA ETS regulations.
Well, what about like a CVS or a Walmart? Now, a question just popped up, but that's also in our heads, like, that when you think of going to test, just schedule it at a CVS. Would that count?
Yeah, well, certainly. One of the things that you could do from an in-house perspective, right, is maybe you don't pay for the testing as an employer and you direct them to go get a test at a CVS or at their provider or at a facility. Urgent care is another example where it's not necessarily buying the Binax Now rapid home test, taking it at home. That's not proctored, but going to the Minute Clinic at the CVS and having that test done through the Minute Clinic is quote unquote a proctor or an observed test. So it really is a person that is evaluating that you are taking the test and confirming that you have taken the test, not so much to take at home.
So what if you're calling telehealth? You have a telehealth service and you're taking the test and showing the results or whatever, or however that would play out. Has that been looked at?
Yeah, that works.
Yeah, actually, that's a great point. I mean, the vendors that we have spoken with who have the observed or proctored self-antigen test, that is exactly how they're doing it. They are booking silos of time where they're going to have a phlebotomist on time, and they'll have 12 different windows open, each one window with an employee, and literally watching them take the test and then validating that test has been completed successfully, and then recording that information into the systems. And so the the in-house methodology would have been, of course, our HR folks and partners and the employers themselves doing that. And to the degree that our clients would want to do that is obviously one of those major questions that would have had to been asked, and still maybe, obviously, but would have had to been asked had the OSHA ETS went forward.
So that would have been valid, but it's awkward, it's challenging, and by the way, all of these things that they would count as proctored, but you're still now talking about your tracking and things of that nature, a system to be able to compile this in an ongoing fashion. Not to mention, and I think we covered this before, who's paying for this? How's it being? Is the employer? And I know that, I think, right, Dan, they came out and they said, no, you don't. The employer does not have to pick up the charges for this. They can determine that the employee, if they're not going to be vaccinated, they would have to pay for the test, right? As an op, they wouldn't be banged for that. That's something.
We should clarify that just a little bit, because I think we talked about this a little bit in the last one, but we didn't go that much detail. It's certainly one of the most common questions we get, so we should definitely address this. There were laws under the CARES Act, right, that said that if an individual, right, not necessarily an employee, but just an individual participant in a health plan, wants to get a diagnosis, maybe they had an exposure or something like that, they can go to their health plan and get a COVID test without any cost sharing. So there's no cost to them.
Right.
But if it's an employer program, if it's for employer health and safety, things like that, then the insurance companies can impose a cost. And so that's where there's a big kind of difference. So the question then, of course, was, well, if this OSHA rule comes out, is it going to say we, the employer, have to pay for the test? And what it did say was that no, the employer does not have to pay for the test unless it's mandated by a collective bargaining agreement or collectively negotiated agreement, or if it's required by state or local law. And we do know that California, does require employers in California to pay for the COVID test. And there's some other different, state laws that I think there's different ways to interpret them, but I think some have interpreted them as requiring it as well. And so I think that's a big, probably one of the most common questions that we get, right, is who has to pay for the testing? And then also we should just kind of make a quick note here as well, that there's a difference between testing as part of a test out alternative to a vaccine mandate policy, versus if you're going to be offering a reasonable accommodation to an employee because of a medical reason, a disability, or religious thing, sincerely held religious belief, right? If it's any of those things, you can use testing as part of that accommodation. But under those circumstances, there is a federal law that there's EEOC guidance saying that the employer has to pay for it under those circumstances. So just wanted to kind of clarify that a little bit.
Real curious. Okay, so I know as it relates to vaccines, you need to provide the employee with time to do that, and also recovery time if needed or whatever. What about testing? A question came over, and I'm curious to know whose time is that on? Can the employer say, hey, you need to be tested, but you need to do that on your own time?
Yeah, so that's going to be up to the state wage and hour laws, right? And even though I am an ERISA benefits attorney. Don't pretend to be something I'm not. I'm not a labor and employment wage and hour lawyer, but I will say in most states, to the extent that you are getting a COVID test as part of a workplace requirement, right? The time that's used, in most states, that's considered to be compensable time. It's my understanding, at least. So employers would have to pay for it, but I think it really kind of depends on those state and local wage and hour laws.
Okay, if we're getting into another area, I apologize. I know I saw your billboard out there on 95, America's Lawyer, with a big number. I thought I could ask you anything.
Are you sure that was me?
Maybe it wasn't. I don't know. And I'm going to go back a second to something I had asked a little bit earlier. And Ray, I think you said the answer, and it probably covers it when you said people are kind of waiting right now with everything going on, kind of holding for a second. But I am curious, and of course we would never name names, but are any clients, and Dan, you probably know as well, have any of them gone through, we've just gone through open enrollment for a lot of folks, have anybody any client put surcharges on for unvaccinated? Has that happened that you're aware of?
Yes, it has, yeah. Ray, you can talk about more detail than me, but go ahead. Yeah.
I just want to explain that, surcharges, there's some challenges with it, especially, and I'll flip it back to Dan, who can go into some of the challenges relative to making sure that the plan is affordable. But one of the things that are often not talked about is management of the perception of a surcharge for a vaccine. And so that is something we can't answer. That's the personality of the employer, what the end results or the goals of the employer are for that particular policy. But what we can safely say is, as long as it's affordable, we are seeing discussion around that. We have clients who've implemented that to put a little bit more gravity to the situation, have people get the vaccine because that's their end game. And we're seeing movement on that. Just like a wellness surcharge for your personal well-being. That kind of strategy, or a spousal waiver surcharge, those types of strategies have been in play just under a different context, and they have been very effective in motivating people to do certain behavior changes for the betterment of the company. Excuse me. And so we do have a number. I can't say that it's a lot, but a number of clients who are implementing them. But the commonality there is that they are our larger employers, right? And so that is one of the things that I don't know if size makes a difference, but you can certainly understand maybe some of the cost implications that some challenges that smaller employers may not have relative to being unvaccinated. As opposed to a larger employer, Brian.
Yeah, and we also have self-insured plans as well, right? And, that's another part of it too, right? It's an unvaccinated person can have huge claims costs on a self-insured plan.
Look at the attorney telling us about the claim implications on it, but it's such a valid point. Yep. That is a protection for the health plan, and something that is so extremely important, because we know that somebody who goes and is admitted into the hospital as a result of COVID-19 will have can potentially become quite a big high claimant.
Wow, look at that. We're right up on it. Was there any last thoughts, Ray, Dan? Are we going to be talking about this again in our live briefing come, a month from now or 6 weeks? Where do you see, will we ever have a time where you just said, I sit down and just relax, not to have to read 22 page briefs? What do you think? Where are we going?
Well, I'll let Dan finish, but I'll start and just say, certainly this is something that may have employers think about an administrative standpoint a little bit further down the line than we had originally anticipated. But I still think there's an opportunity there to evaluate maybe the tracking mechanism only, maybe not the testing, but the tracking, making sure that you've understood your population at the very least, and making sure that you understand how many are vaccinated versus unvaccinated. If you are in a high touch industry, like a banking institution, schooling institution, and you need to have some type of visual passport to ensure entry into your building, those tracking vendors have those types of technologies. So the OSHA ETS, I combined my words there. The OSHA ETS didn't necessarily blow up that type of thinking for a lot of our employers. And I think that's still an evaluation that clients should be making here over the next several months. Dan?
I think that's a really good point. I think you kind of took the words right out of my mouth. So I don't want to.
How do you do that? Can you let me know?
But basically, right, I mean, it's always good to have an understanding, right? To take surveys, obviously keep them confidential. You don't want to be getting, family medical history information from your employees, things like that. But, it's always a good idea to be aware of what's going on at your workplace, to take surveys, right? To work on that interactive communication. And even if this OSHA ETS rule doesn't happen at the end of the day, right? I think there's some really good lessons here about what employers can do to be prepared to lower their health insurance costs, and put policies in place that make sense. And so in some ways it was kind of like a test run. I mean, even if it doesn't work out, right, it was a good test run for us, because we had to have a lot of meetings with our clients across the country and kind of look at like what they can and can't do, what they're prepared to do. We got a sense, right, as to how deep their bench is, essentially, right, to prepare for something like this. And I don't see this ending. I mean, even if, let's say, this version doesn't work, right? It's possible that the Biden administration could go back to the drawing board, right? And we could see maybe a more simplified version, because it is a big priority for this administration. So look, I don't want to get ahead of myself though, right? I think let's take one thing at a time. But this really did, force employers to really kind of be prepared, to look at their policies more closely, to look at their benefit plans, to think about things like premium surcharges and other things, and their bottom line, their claims costs. So in that sense, right, even if it was just a test run, it forced us to take things seriously and look at things more closely in those areas.
Well, I know we're a little bit over, but I do want to say that while we'll close this out, we're going to hang on just for a few more minutes. I know that others need to get to other meetings and what have you. We hope you found this valuable, beneficial. Hopefully we clarified some things for you. It looks like we're going to continue to clarify this issue as we move out through the next several months. We will do that. We will make sure that you stay informed through all of our resources. But, Etta, you had a question, and if any others have some questions, you can hang back a second and we'll try to answer those for you before we let everybody go. But for those that do need to jump off, thank you again for participating. We will see you at the next live briefing, and we're going to try and answer some of these questions because I think it's important for us to clarify for those that are seeking that clarification. So thank you for those that are jumping off, and for those who are staying on board who have asked some questions. I'm going to throw them over to Dan. So Dan, I don't know if you saw that, but Ed is asking, can you elaborate on the employer having to pay for the COVID test when that's part of a reasonable accommodation? I found language in the ADA saying that if the employer requires the employee go to a specific, look at me, I have to scroll down, medical provider, then they have to pay. So can you elaborate on that?
Yeah, and so there's EEOC guidance under the ADA that the interpretation of that is, and like I said before, I am an ERISA attorney, a benefits attorney, and a benefits consultant, but I am not a specialist in labor and employment law. But my interpretation of it, and from what I've attended other webinars from other law firms and spoken to my other lawyers I know in the New Jersey State Bar Association, for example, and our consensus view, or I guess the most commonly way to interpret that EEOC guidance, is that employers who are requiring regular testing as part of a reasonable accommodation under the ADA do have to pay for that testing. So that's, I think, the consensus view. It's not 100% clear. If you just kind of read it on its face, it's not 100% clear. Obviously, it was written before the COVID-19 pandemic. And so it doesn't say, like, if there's a COVID-19 pandemic and the employer requires COVID-19 testing, then employer has to pay. But it's been interpreted to mean that by the consensus majority of attorneys out there that in this area that I've spoken to.
So they're going to have to check ultimately with that employment lawyer who's on the billboard out there.
That's right, Morgan & Morgan or whatever their names. Yeah. No endorsement here, whatever their names are.
Yeah. One other quick question, and then we'll see. Can the courts modify this? Or is it done? Like, hey, we reject it, go back to the drawing board. Can it be modified at the appeal stage?
Yes, the stay part can, yeah. So they can, yes. So that's my understanding. So the Sixth Circuit can modify the stay that was ordered by the Fifth Circuit on November 12th. So yes, that's my understanding. They can do that.
Well, we'll end on a positive. Yes. With that, Thanks, everybody. We really appreciate it. And if you do have any additional questions that you didn't think of on this call, by all means, reach out to us and we'll try to get an answer for you. Thanks again. Have a great afternoon. We'll talk soon. Take care.
Thank you.
Thank you.